Good morning or afternoon, wherever you may be. Thanks for attending today's webinar. There's a lot of material to get through in a very changing landscape, so I'm going to try and make good use of the hour that we have together today. Today's presentation: managing fiduciary risk, fact, fiction, and what may be next. A few housekeeping items before we jump in. First of which is lines are muted, obviously, to help control for audio quality. That said, we're more than happy to take questions. It will be a somewhat conversational approach to the topic today. So if you have questions as we go through, we'll try and get to them at a time that's appropriate. We're also recording today's presentation. So to the extent that you want to go back and listen to some of the wise advice that you'll be receiving today from the panelists, you'll have the ability to do that, also distribute it to colleagues to the extent that that is useful. And last but not least is we will be sending a copy of the slides. Again, a lot of it will be conversational today, but there is some interesting content slides that may be of interest to you from a training perspective within your organizations. So with that, I'll get started. Would like to first welcome what is a really strong group of panelists today. I'm joined by two partners from Faegre Drinker, Summer Conley, as well as Rick Pearl. And then in addition, joined with the managing principal of Euclid Fiduciary, Daniel Aronowitz. Daniel brings a really unique perspective that I think will be useful today as it pertains to what's happening in the litigation side. So while we talk a lot about settlements and what's happening from a litigation perspective, Dan is directly in the middle of the discussions and decisions about when to settle, when to pursue, when to litigate, and how that impacts plan sponsors and plan operation. So from an agenda perspective, we are going to talk a little bit about the state of play, give you some information about what's happening from a litigation perspective. We're also going to talk about some of the fictions, and I think there's a great number of them as it pertains to plan sponsors and fiduciaries attempting to eliminate or mitigate their liability relative to these fiduciary breach cases. So some of those things may make sense, some of them may not make sense, and to try and give you some information. I would argue, and I think we'll argue today, that some of this is a math equation, regrettably, right? That we've turned this into a very simple process by which litigators are able to solicit through claims that may not have a lot of accuracy or merit, settlements from plan sponsors who have a need to move on and do other things. We'll talk about really the three critical gateways as it pertains to litigation. I think obviously first and foremost is to avoid it entirely. That is your best practice, quote unquote, from a fiduciary breach perspective. That said, if you find yourself in litigation, it certainly appears to be the most successful approach that plan sponsors have been able to utilize in litigation is trying to get the litigation dismissed at earlier initial stages. And then last but not least is if that does not work, and frequently it doesn't, as Dan will talk about, what can you do to be successful in the litigation process? And then we'll close it out with what's happening on the horizon. What I'll say is plan sponsors tend to adjust their best practice and methodology and approach based on what's happening from a litigation perspective. It's not going to be terribly surprising to learn that plaintiffs' firms do the same. They learn things in the courts, bring new claims, take new approaches as they try and modify their business model to meet a changing litigation landscape. So let me start with just some factual data. If you look at the number of retirement plan excess fee litigation cases, the volume continues to be high. If you look at 2020 through 2022, you're looking on average north of 80 cases a year on the excessive fee lawsuit side. And the cases are with brand names that people are generally relatively familiar with, large employers that have reputations. Maybe Rick or Summer, why do you think the number of lawsuits have been increasing? Is it because there's rampant problems associated with how these plans are operated, or are there other reasons that are driving increased litigation?
Well, hi everyone. I'm Rick Pearl. Summer. I can chime in first.
Sure.
So the ERISA space, the area of law, is itself rife for disagreement, and the reason has to do with how ERISA is structured. ERISA was drafted in a way that it largely imposes standards of conduct on people who are fiduciaries. So benefit plans committees, individuals, they have to comply with standards of conduct. What ERISA doesn't do is it doesn't micromanage characteristics of benefit plans. Because of that, it is fairly easy to file a complaint that alleges that a plan has certain characteristics that are reflective of imprudent conduct and survive a motion to dismiss in most instances. 99% of the cases then are going to settle. Many of them are going to settle for under the estimate of total defense costs through trial and appeal. And plaintiffs' firms will settle on a class basis, which allows them to recover, it's a common fund doctrine, allows them to recover a portion of the total settlement. So a third, something like that. That just gives incentives. You can draft a complaint, you can survive a motion to dismiss, you can settle for several millions of dollars, and you get a fairly significant award of attorney's fees. It's also true because the complaints in these cases are fairly boilerplate. They don't have to be that fact specifics. There have to be some facts about plan characteristics, but you can piece that stuff together in one way or another. Sometimes you piece it together in a way that's inaccurate or misleading, but even those can often survive a motion to dismiss. So that's why I think you have seen more and more lawsuits. I think it is not reflective of some rampant problem in the space about fees, investment options. I think plans are managed today better than they have been at any time in history, but it's not changing the fact that there more and more lawsuits are being filed.
Yeah, I'd have to agree with you, Rick. I mean, I've sat in on just a ton of committee meetings, and I think they're all going through a good process and really doing their best to look at the fees and look at the options and go through it. I certainly don't think it's a result of chronic wrongdoing or something along those lines from the plan committee standpoint. I think it's really what gets more to what you're talking about as far as the ease of being able to file one of these lawsuits and then try to settle it.
One of the things I thought was interesting in kind of preparing in our discussions about what's happening in the marketplace is I think generally folks think of Jerry Schlichter as being the grandfather of these fiduciary breach lawsuits, but as a grandfather, he seems to have a relatively prodigious tree of additional plaintiffs' firms. Dan, maybe a question for you, given the data that you shared about the number of firms that have entered this market. I think there's certainly a lot of noise around these being kind of copycat cases, but are there different approaches that different firms are taking, relative the litigation in retirement plans and ERISA cases, or are the approaches all really just boilerplates of what Jerry's been doing for now several years?
The Schlichter firm is clearly the pioneer of this type of litigation, and if you read their fee motions, they'll tell you that they invented this line of litigation, and they did. And they filed many cases in 2006 through 2016. Since that time, they focused on high cases that have a high level of damages, usually proprietary investment cases. And so that's what they're focused on. So they take less cases, even though, as you know, people think of this line as a Schlichter line. The Capozzi law firm in 2020 filed 40 of the 100 cases, and last year 20 of the 88 cases. This is the list of last year's cases to get a feel. And so they're filing the same type of, so there are cookie cutter cases where they bring both record keeping and investment fee litigation. Miller Shaw focuses on investment imprudent cases. They filed 11 cases against BlackRock LifePath Fund, maybe even 12 of their 15 last year. And sometimes they work in conjunction with the Capozzi law firm, but they're focused on one type of litigation. While Chesky law firm is prolific, they're like Capozzi, but they focus more on record-keeping fee cases and less on the investment fees. Our theory is that they are going for the easy settlement, and there's less standing argument on record-keeping fees. Wenzel's a new law firm, and they used to do Cobra notice cases, telling big companies that you're scaring people into not taking Cobra when they're laid off. And now they've gotten into this, sometimes using Morgan and Morgan for the people as their co-counsel. Nichols Castor have been a consistent player, filing 5 to 10 cases per year. They focus more on investment cases. And so that's, but there's a lot of copying going on, but as you noted, some of these firms focus on what they're better at.
So a question just came through the chat, which I thought was a good one. We get it from clients a lot. So are these firms representing, and they clearly represent plaintiffs, right? There has to be a participant, there has to be damages. Is the case where a participant says, hey, I feel like I've been damaged. I'm going to go figure out who does this kind of litigation. And I find the website of Miller Shaw and give them a call and say, hey, I think I've been taken advantage of. Or is it the other way around, that Miller Shaw has to go find some potential participants that they feel may have been disadvantaged in a fiduciary breach type case?
We know of no instance where a participant in a large defined contribution plan in America woke up one day and thought their fees were too high or their investments were underperforming. This is a lawyer-driven business model that these law firms are out searching Form 5500s, finding certain criteria that they think may make a lawsuit, and then they try to find disgruntled former employees. From what we can tell, every single case has former employees. Sometimes there's standing issues, and the courts have been very generous on standing. Sometimes these employees are no longer at the company. Sometimes they're not even in the plan anymore. Sometimes they're not even in the investment options that are being challenged. And sometimes courts allow that. But these are disgruntled former employees that are found through internet marketing by these law firms.
And I'll add, the internet marketing's gotten quite a bit easier if you think about it. And for those of you that work in the business-to-business environment and may be associated with advertising, right? It's very easy to identify people and where they've been employed. Think about your LinkedIn profile. It's every place you've worked, when you worked there. To find someone who may have been an employee and therefore a participant in a retirement plan between 2015 and 2019 cost you virtually no money. You send them an in-mail. And you have almost unlimited access to potential people who may be interested in some form of settlement. It's made it much easier, frankly, than the initial days, where at least you had to put an advertisement in the newspaper and gather everybody up at the Red Roof Inn to see if you could find some folks that may have, an actionable claim under the terms of the plan.
Yeah, I will just add a couple things to that. I have copies on my computer of the ads Schlichter Bogart used to run in local newspapers. Now it's Facebook, it's social media, but there's also a firm, I believe they're in Colorado, that's running TV ads, very much like the TV ads that you'd see for were you injured in a car wreck. So they are actively seeking out individuals to convince them that they have been wronged by their 401k plan. The other way these come up is you have a former employee who's disgruntled and will sometimes go to a labor attorney, and the labor attorney will determine, well, there is no case here, but do you have a 401k plan? Because I know somebody, and they'll refer it out and potentially get a piece of it. So that's another way these come up.
So as we get into the discussion here, I thought it was important just to kind of set the stage. We're going to talk about different parties, right, as it relates to this litigation. And the purple organizations or organizations that may be a claimant to a case, right? Clearly, the retirement plan fiduciaries are the focus of the litigation in these cases. They were imprudent. They paid too much. They had picked the wrong investments. Those claims are being brought in most cases by participants as represented by these plaintiffs' firms. We're going to talk about this later, so I think it's important to kind of identify the board of directors, right? So in the case of most of these organizations, what you have or likely have is some delegation that was made from a corporate board or a nonprofit board down to a fiduciary committee that's exercised or charged with providing all the fiduciary oversight to the plans. We'll talk about that because we're going to circle back to it later. It's important to point out that the Department of Labor can be a claimant in these cases. We're not going to talk a lot about Department of Labor cases today, but they are a potential claimant. And then there's certainly fiduciary consultants, investment consultants, fiduciary advisors under whatever name or terminology you'd like to use, but under ERISA 321 or 338 that in some cases are getting looped into the litigation. And then we're represented today with both Rick, Summer, and Dan with representation from both legal counsel, right? Those charged with kind of defend these cases, And B, in the case of Dan, those are responsible for ensuring those fiduciaries and potentially boards of directors against these fiduciary breach cases. Let's talk about the fictions first. I think I see fictions really coming from two different angles, right? The first one is plan sponsors. Occasionally I'll sit in a committee, we'll talk about litigation, and they'll say, hey, what can we do to make our employees happy so that they won't, feel motivated or incented to litigate? I think generally that's viewed as potentially a fiction, especially based on the notion that Dan said that these cases aren't really participants who are aggrieved. They're instead counsel looking for potentially participants who would like a settlement. Even the notion that providing really generous benefits will somehow prevent litigation, right? The notion that if we have a really great match or really great profit sharing, that would avoid litigation. Or third, just the notion that transparency will protect us, right? If we provide all of our notes and documentation about what we've done at the fiduciary committee, we'll give them all of our minutes so they can see all the great process work that we've been doing. I think the intent is good, right? I want to show how good the work is we're doing, but regrettably that has its own set of risks that I'll let you all talk about here as we go. And then there's other, I think, fictions that are being promulgated by the industry. I hear too frequently, well, if you hire a 338, that will absolve you of any responsibility for fiduciary investment performance. So you can kind of walk away from that risk as being one that's material. Perhaps if you take yourself out of a single employer plan and integrate into a larger PEP, that's going to somehow protect you against fiduciary litigations, or even one that I think is really commonly discussed and I think is best practice and everyone should have. But the notion that great process will prevent litigation, I think is regrettably an industry fiction, right? So Summer, let's start maybe with the 338 piece. I think, certainly hiring a 338 is a totally reasonable decision for any plan sponsor to make, but increasingly hearing it being sold as something that provides some kind of blanket protection. What are your thoughts on both what a 338 can do, can't do, and whether that provides or what types of protection it might provide?
Sure. No, happy to chat about that. So, I mean, just to kind of set the stage, we've got, the typical investment advisor is either a 321 or a 338. In the 321 context, the advisor is making recommendations to the committee. They are still a fiduciary, but they're making recommendations, and the committee is ultimately deciding on what investment options to offer under the plan. On the other hand, with respect to a 338, the 338, also referred to as an investment manager, is also still a fiduciary, but they're the ones who are actually deciding on what those investment options are going to be under their plan, as opposed to making a recommendation. Both are, perfectly legal, and you see both in the industry. I guess what you're, as far as kind of whether or not the 338 absolves you from liability, it takes away the responsibility of actually selecting the investment options, but it does not remove all fiduciary responsibility for the committee. Essentially, the committee still has the fiduciary obligation to select and monitor the 338, and so has to go through the process and make sure it's exercising, reasonable discretion, and going through the whole process of selecting and then monitoring that 338 to make sure that they're continuing to do their job appropriately. And so it's not really a question of removing liability, it's just changing it. So you're responsible for selecting the 338 as opposed to selecting the investment options that you're offering.
Dan, maybe as we move down kind of the PEP piece, with the advent of Secure and then Secure 2.0 for 403B plans, we certainly have seen PEPs talked about a lot, and certainly in the marketing of PEPs to plan sponsors, there seems to be this implication that by opting in, again, the PEP somehow assumes the fiduciary responsibility, and that I, as the plan sponsor and the fiduciary committee, can kind of walk away from those obligations. As an underwriter, what are your thoughts, and what protections do PEPs provide that plan sponsors wouldn't receive in kind of a standard retirement plan setting?
We think there's an appropriate point to put in terms of some fictions, because a lot of PEPs are sold that we will remove your fiduciary liability, and then we're told that I'm in a PEP, and so I don't need fiduciary liability coverage because the PEP absolves me. And it's similar to a 338 situation, and someone else is administering your plan, but you still could be accused of making a bad choice. And you have to ensure that the fees of that plan are good and the investment options are good, and you can also be sued in the same lawsuit as the PEP. We found the PEPs to be litigation magnets. Many of the largest PEPs have been sued, and some of the cases are still working their way through. And the other problem with the PEP is that you're getting one size fits all in most cases. And so if you become a certain size, you may not be right for that PEP if they do not adjust what your fees are, or even what your investment options are. So it's good for someone that's super small if you're leveraging a larger size, getting you something better, but you still have the responsibility to ensure that there was a good decision to go into a PEP. Until the PEPs give full indemnity to you for breaches of fiduciary duty, which I don't see anyone offering, then you have liability if you join the PEP. And by the way, I think it'll be a great business plan for someone offering a PEP to give full indemnification, but we're not seeing anyone offer that.
So, Rick, I've done more fiduciary trainings for committees than I can count, and what we always say is, hey, good news, ERISA is a process law. So, great process, great outcomes. So, why is it that an elite process doesn't protect us from litigation, knowing that it's a process law?
Right. So this has to do with the difference between someone being able to file a complaint that will survive a motion to dismiss and start the process of discovery, document production, depositions, and the ultimate merits of a case, whether or not the plaintiffs can actually prove their claims. So let me give you a brief example. But let's say everybody on this call decides we're going to put together a 401k committee, and it's going to be the dream team. We'll get the U.S. Secretary of Commerce, the director of the National Economic Council. We'll get everybody that we need to get, and that they're going to meet once a week. Outrageous things, and they're going to approve the investment options and the fees and the communications and all the characteristics. That's not going to stop them from getting sued. Let's say the plan doesn't have collective trusts. A lawsuit could be filed saying a prudent plan should have collective trust. Therefore, something must have happened behind those closed doors to cause this imprudent characteristic. Or a fee arrangement with the record keeper that doesn't have a rebate account annually. 5,500 filings that have a suggestion that the fees were $60 annually per participant, even though that number includes individualized charges like quadros, loan processing, things like that, not real per participant record keeping fees. You can piece together a complaint that might give a judge at early stages, particularly, an impression that something might have been wrong. Earlier Dan was talking about the BlackRock cases. The interesting thing about the BlackRock target fund cases is that they are challenging plans for chasing low fee target date funds. The actual basis of those claims is that the plans acted imprudently by seeking out target date funds that had the lowest fees. You can get scared by these lawsuits into doing one thing or another, but ultimately what the process is going to do is protect you from ultimate liability. It's very, very difficult to stop someone from suing.
So let's get into the math and facts of what's happening in the litigation space, because I do think that there is some kind of mathematical formula that you could probably boil some of this down to at the end of the day. Dan, you had provided some information about the size of the plans that are being sued. So in looking back, plans over $1 billion are generally the targets, and I would argue or assume at least that the math of that is that if you've got $1 billion and you're overpaying by a small amount of money per participant, you've at least got something to settle on. If you've got a investment imprudence case, then you're looking at positions that are obviously larger, 17 cases between $500 million and $1 billion, and then making your way down into what are ultimately the smaller cases and approaches. I thought the interesting information was just given how few kind of mega plans there are in the marketplace, what that means from a statistical perspective relative to your likelihood of getting sued. So, based on that, an ERISA plan with more than $1 billion in assets has about a 7.5% chance of being sued in any given year, potentially increasing with each given year, since once you get sued, it's pretty unlikely that you're going to get sued again, at least in the next 2 or 3 years, although certainly not impossible, as some plan sponsors have learned. And then these smaller plans with ultimately, under $1 billion, less than 500 million, a much larger volume, much less likely to be pursued in litigation. Dan, this is going to come up a little later, but maybe you could speak to it now. As we get into the process of having these suits that do largely look similar one to the next, there are differences, as you mentioned, between the various law firms' approaches and types of cases. Is there a point at which the district courts get tired of these cases and begin to turn them away in higher volumes than they certainly have over the course of the last 2 or 3 years?
There are still lots of federal district courts across the country, but we have seen that there's been some shift since the summer of 2022 when 3 circuit courts ruled favorably for certain plans. We are seeing more cases being dismissed. Most of the dismissals are with the right to amend, so they're not complete victories. And we're seeing some investment claims being dismissed, or in some complaints, some record keeping claims being dismissed. So we are seeing more courts being skeptical of these cases. There's a particular court in Wisconsin that seems to be fed up after the Oshkosh case and has dismissed about 8 cases. Most of those are Walczewski cases because they file cases close to where they're situated, and they've sued many of the plans. And so there is one district court that has been very, very favorable, 3 circuit courts that have been more favorable. But we still see the majority of cases are still not being dismissed, and we still see some anomalies in the cases that don't make sense to us. We're seeing some courts allowing, for example, on standing, some courts say you have to be invested in the investment option in order to sue. Many courts are saying you just need to be invested in one option. Makes sense to us on a target date glide path, but it doesn't make sense on another investment. So we're not winning all of the standing cases. And so there's still significant dislocation where the courts aren't ruling the same way. That's just on standing. On record keeping, we're seeing some courts saying you have to prove services to services. I think a lot of these courts don't understand that most record keeping is the same service, and what they're confusing is non-record keeping fees that are being included in the Form 5500. So, but some courts say that, some courts say you're allowed to put on evidence that you have revenue sharing and that that's not that the plaintiffs have put out a false record keeping fee. Other courts are saying that's an issue of fact. And so what we're finding is there is more maturity in the case law than there was a year ago, but there are still a lot of decisions that make no sense to us, and it still feels like a crapshoot to us, which we find unfortunate.
Well, maybe that's a good transition then to kind of the next topic, right? Which is you are in the business of providing insurance to fiduciaries, right, against these cases. And obviously the development of case law is important. The best possible outcome, I can assume, for a plan sponsor is the same as the best possible outcome for you, which is that you never end up in a courtroom. We've seen a huge change ultimately in the underwriting process for this fiduciary liability insurance, and knowing that not ending up in a courtroom is kind of the ideal solution. Can you talk a little bit about the things that your firm focuses on from an underwriting perspective to kind of identify the risk factors that would increase at least slightly the likelihood that you're among the cases that get pulled in the next year into potential litigation?
What makes us different than the other national fiduciary markets is we are classic underwriters, and we write the best plans in America. We don't need to write every plan. We're not portfolio underwriting. So we are looking for plans that we think have a lower risk of being sued in an excessive fee case. We're not perfect goalies, but we think we're better goalies than because we're focused on fiduciary liability. So we are looking for plans that have a good fiduciary process, and we don't often talk to the plans themselves. So we first look at who their professionals are and do they have a professional advisor for their investments. Most plans do, and that's lost in this litigation that most of these fiduciaries are not working independently. We're looking at the record keeping fees, and We have our own proprietary database. We've seen thousands of 408B2 fee disclosures. We know what the reasonable fees are. We don't agree that $35 is the right record-keeping fee for a certain size plan just because Schlichter said that in 2016, or Capozzi, Adler Law Firm says now it should be $25. We think there's a range of reasonableness. We do prefer accounts that have per participant fees and are not asset-based, because once you get over $100,000 in an account size, asset-based may not make sense. We know that many plans over below 100 million have asset-based, but we think once you get a certain size, you should be negotiating a per participant fee. We like to find plans that have limited revenue sharing, and if you do have revenue sharing, that it's clearly demonstrated that it's allocated back to the actual participants that had the revenue sharing. On investment fees, we're looking at whether you are in the lowest share class. That's obviously the number one factor that will lead to an excessive fee case that sticks. If you're in the wrong share class and it's the same fund, just at a different price, wholesale versus retail, that's a problem. And we think it's incumbent on the investment advisors to help their plans with share class, but we're looking at share class. We're looking at investments and are you in reasonable fees? We prefer obviously index target date funds, but as Rick told you, those got sued as well. So we want you in the lowest share class. We want if you're in an active target date fund, we want a target date fund that's performed well over the last 10 years. And we don't look at 1 or 2 years. We think 5 to 10 years is better, but there are certain target date funds like American Fund and T. Rowe Price. They've done really, really well, even with active management. So if you're in the lowest share class of those investments, we look at how you compare your investments, because investment performance is becoming more of what the plaintiffs are going after. So we're looking at low administration fees, low investment fees, lowest share class, and we're looking at whether you have excellent investments and who are your providers and how are you monitoring it. That's our basic underwriting model for a defined contribution plan.
Thanks, Dan. Yeah, we've had the work of helping clients prepare kind of the underwriting piece, and I think that ties out exactly to as Dan explained it. I think there are 6 areas where, from an underwriting perspective, you need to be pretty comfortable that you're in a good spot here. It doesn't, again, eliminate the likelihood of you being pursued from a litigation perspective, but does seem to provide the best assurance against some of the easier claims in these cases. Summer, knowing the litigators are in search of targets, right? That's what we've talked about, and that even with the increasing number of litigators, everybody can't get sued all at once. It takes time, and you got to pick your targets to have the best likelihood of securing a judgment, or maybe more likely a settlement. Are there other things that plan fiduciaries can be doing to potentially make it less likely that they're going to be the next target?
And I think Dan raised obviously a number of great points and things to be thinking about. Other things that you can take, and as we've all been talking about, no matter how great you are, that doesn't necessarily mean you're not going to get sued, but different steps you might be able to take that might minimize it. There's been a lot of talk about the arbitration class action waiver provisions and adding that to your plan so that they can't bring these large class actions and have to arbitrate on an individual basis. There's obviously pros and cons with respect to arbitration. Not everybody is a fan of it. And it's, there's still a lot of open questions in the courts as to whether or not that's enforceable. Some circuits have clearly allowed it. Others have kind of said there's issues. So at some point it may go to the Supreme Court. But generally, I think if you put that in the plan, you've at least got one more hurdle that plaintiff's firm is going to have to pass in order to bring their suit. And so it's, a potential, making it a little bit harder to bring that. And so I think that's certainly something to think about. Along those same lines, we've also been seeing a lot of venue requirements, so that they have to be brought in a certain venue that's at least convenient for the plan and maybe potentially inconvenient for the plaintiff's firm. So I think those are just a couple things that you might want to think about putting in your plan. Again, still open issues, and there's a lot going on it, but it's at least one more hurdle that might make it more difficult.
Dan, you alluded to this earlier, right, that, once you do get sued, so let's say none of that works, we've underwrite it, the ball gets past the goalie in Dan's terms, and all the tools and things that we've done that Summers alluded to have also not prevented us from being a potential target. It does look relatively troublesome when you look at the data from 2022 about wins and losses, notion being that the next opportunity is to try and get the case dismissed. And if we look at just wins and losses in 2022, a lot more losses than wins, at least in full motions to dismiss. You commented on this a little bit earlier, but, projecting forward, do you think that these 2022 percentages will extend, or do you think that there is more, perhaps in the Wisconsin example, more opportunity to swing this motion to dismiss more favorably toward plan sponsors who, do have a good fiduciary process and can demonstrate that and can attack some of these plaintiffs' motions?
We predict there will be more victories on motions to dismiss in 2023, and the first month of the year bears that out. The prolific Wisconsin court is obviously going to tilt that in favor. If you live in the Seventh Circuit, when Summer talks about venue clause, we love venue clauses if they work, because you just want to get sued, and surprisingly, Chicago, Illinois, and you have a better shot of getting it dismissed. The Sixth Circuit had the Common Spirit case. That was the first to start stemming the tide, and you'd be surprised that seems to be like a 50-50 split on courts that are following Common Spirit. The 10th Circuit has the Barrett Gold case, and let's see how that goes. And so more circuits are doing what the Supreme Court should have done, and making it a little bit harder for plaintiffs and making them put more proof. So we think there's going to be more cases dismissed this year. At the same time, the plaintiffs aren't going away, and we think that may even lead to more cases being filed when they realize that they're not going to win 4 out of 5 cases. They're maybe only going to win 1 out of 2. And so I think that we may find that they'll just actually file more cases. This is still a lucrative business model, even if half the cases are dismissed. And you also have to factor in that a lot of the dismissals end up, they just amend their complaint, and maybe they don't get to keep the investment fee claim, but they get the record keeping fee. So some of the victories, you have to wait until it's all over. And this is a wash, rinse, and repeat. Some of these times they file 3 complaints in a row, and there's 3 motions to dismiss. And sometimes a motion to dismiss is educating them. But it is more hopeful than it looked a year ago when we had the Northwestern case come out.
Dan,
So,
if I could just
go ahead,
add
Rick.
one quick thing to that. As litigators, one thing I've been advocating for many years is that there's a provision in ERISA itself, and there are a couple Supreme Court cases on this point that say that the assessment of whether there is a potential breach of fiduciary duty is context specific and fact specific, and is supposed to be. Meaning, you can't just come in and file lawsuits saying, you shouldn't be able to come in and file lawsuits saying that fees were X number, therefore there must have been a breach of fiduciary duty. I think what we've been seeing in recent years, especially after the Northwestern case sort of reiterated the context specific requirement under ERISA, is you've finally seen some district courts start to actually do this. Start to think about, what does it mean if a plaintiff is coming in with a Form 5500 saying the record keeping fees were a particular number based on that form. Courts are starting to look at Form 5500 to determine, what does that number really tell you? If anyone here is involved in a lawsuit, or something to talk about with your lawyer is, how do you educate judges on that? How do you get judges to understand that this problem that we're seeing is, in my view, because of a departure from the intent of Congress, the intent of ERISA, and even the intent of the Supreme Court, which was to make district courts gatekeepers, make district courts look at complaints for a complete contextual, factual development that might suggest a breach of fiduciary duty, not some chart that you see in these boilerplate complaints showing, 5 plans that had lower fees than the plan that's been sued. In my opinion, more is needed, and I think we're seeing courts start to lean that way, and hopefully that trend will continue.
So maybe let me jump on that for a second, because we did have a question pop up, and I think this is probably a good time to track it. If we talk about context, right? So when we go back and see the spate of lawsuits that was filed against ERISA retirement plans and higher education, right, that had been operating under arguably a very different set of rules and obligations and even funding contracts, pre 2008. Is it surprising to some degree that there wasn't a stronger context argument made? I mean, so many of those plan sponsors, NYU obviously was successful. I think Yale's still litigating. There was maybe a couple dismissals, but a tremendous number of settlements. Is it more surprising that context wasn't argued? I mean, we're talking about fact patterns or issues that kind of operated out of a very differing set of regulatory requirements. And I'll throw that to all three of you or any of you who wishes to take it.
Well, I love to take that, because the problem of the university cases that really started all of this, even though there were cases before that for 10 years, but the 20 cases that were filed in 2016 and 17, we have to be honest with ourselves that not every case is the same. And we felt like defense firms treated every single case the same. And so we ended up with a high fee case going to the Supreme Court. The problem with the university cases is there may have been merit to some of those cases. And the courts don't understand any of this, but I think their gut was, wow, this sounds like high fees. And there are a lot of problematic facts in the Northwestern and other cases. When you have uncapped revenue sharing that equals $200 and something per participant in a $4 billion or $3 billion plan, the judges have no way of knowing in context whether that's a high fee, and they don't know if $35 is the right number. They're skeptical of that, and that probably isn't the right number either. But somewhere between $240 that Schlichter alleged and $35 is probably the right number. And the investment fees, when there, out of 239 investments in Northwestern, 139 or so are in wholesale with wholesale share class, when they're being told you can get the exact same investment for 20 basis points lower. Those are problematic cases. And so it's really hard to argue context when your facts are bad. And the lawyers did a really good job making the best of it. And the Northwestern, which seems to have an unlimited budget because they're out of insurance and they keep litigating, and everybody else has settled for an average of 13 million. And good for them. They keep litigating. It's really hard to argue context when your facts aren't good. Come forward 6 or 7 years, and many of the cases that are being filed now don't have high fees. When you sue BlackRock funds that have Mercer as the investment advisor, and they're top-notch Microsoft and Capital One, and the all-in fees of the plan are 15 basis points, all-in fees. When you're talking Northwestern had all-in fees of 80 basis points, you're now suing plans that don't, that these are bogus cases now. And so we now have the opportunity to talk context when the facts are different. So we used to tell defense firms, don't file a motion to dismiss in every single case, because maybe the case doesn't deserve it, and then you won't have courts being skeptical. In the Hy-Vee case last year, the defense firm said the plaintiffs are filing a copycat case, and they do this every single time. And the court said, don't you do the same thing every single time? Don't you have the same playbook where you file a motion to dismiss every single time? And so what we tell lawyers, that don't do the same thing every time. I think this is what makes Rick Pearl good, is every case is different, and some cases have merit and some cases don't have merit. But we're too guilty about insurance companies and defense firms of using the same playbook every single time. And we need credibility with the judges as well, so that when you do have a bogus case, we're able to say, look, this is a really low fee, or this plan had process, and here's the context. And so that's our perspective on the difference between the 2016 cases and the cases being filed now.
That's actually a really good segue to my next question. So let's assume we have good facts, Rick. Let's assume we have good facts, because I think Dan made the good point that trying to get a motion to dismiss if our facts are bad, probably not a great situation to be in. But let's say the facts are good. What characteristics of a plan, a committee operation would be optimal if you're going to be successful in one of these motions to dismiss?
In a motion, I would go back, if we go back a couple slides to the characteristics Dan was talking about earlier about the targets. What we need to understand is there is a disconnect between what ERISA actually requires and what the plaintiffs will allege it requires. And interestingly, the $35 number keeps coming up. It's been coming up for years, and it was a Schlichter imagination many years ago as to what the $35 number that plans are shooting for today is not the result of normal active market forces among arm's length parties, negotiating record-keeping fees. It is the result of a reaction to people terrified of being sued. And I know this for a fact, there are record keepers out there who take losses on their record keeping arrangements because they try and make up money in other ways. So what has happened here is you have these lawsuits pushing things in directions where they normally wouldn't go, which itself is contrary to and I talk about the intent of ERISA because I think that ERISA's legislative history is underused and is helpful in many regards in many of these cases, but it's contrary to the intent of Congress, which was to give some deference to the 401k fiduciaries who are supposed to make these decisions. Now, as Daniel said, look, if you have a plan that has $500 per year per participant in record keeping fees, that's the type of lawsuit that I think objectively reasonable people will say, a judge might need to look behind that closed door into that process and figure out what went on there. There may be an explanation. We could think of facts where a judge might say, okay, for this plan, for these participants, given what they wanted and what they had set up, maybe I don't second guess that. That's possible. But when you're talking about making the most of the motion to dismiss, if you really want to win a motion to dismiss or you don't want to get sued, go through the complaints like Dan does and make a list of all the reasons all these plans were sued and just say, take all those things out of your plan. Now, that's not going to save you, by the way, because the theory is going to change next year then. Then if you take all those things out of the plan, then the accusation is going to be, how dare you take all those things out of the plan? Because you should have had at least a couple of them for some reason or another. But, at the motion, I just want to reiterate, at the motion to dismiss stage, as a matter of federal practice and procedure, the court is very, very limited into what the court can consider. It has to pretend as if everything that plaintiffs say in a complaint is true. Take it as true. There are some exceptions to that. If there are certain documents that are referenced, you can bring that in. If they rely on Form 5500s, you could bring that in. But if you have a great process and you want to prevent yourself from being sued, you're going to have to put together a plan that will not have any of the characteristics that would garner the attention of plaintiffs' firms.
And that's a challenging issue, right? I think a number of those things are relatively popular, and there is this kind of always this balance where you have an industry that's trying to innovate and do things that are more effective. Those things are new, unique, haven't been through courts, and it creates some risk when you decide that you want to bring those, despite the fact that you may have a belief and you may be accurate that they could help participant outcomes. So Rick, maybe, we weren't successful, right? Didn't get the motion to dismiss. A couple of the claims were dismissed, a couple weren't, which seems to be pretty typical in these cases. As you familiarize yourself with these cases, because I assume that in most cases, you're new to the case at some point, right? It's only when things get bad that they call Rick and say, hey, we need to, we need some help getting out of this particular pickle. So what are you hoping to see when you start really getting into the meat of one of these cases, whether it's a fee case or an investment in prudence case? I mean, what are you hoping to find?
In addition to characteristics of the plan, investment options, fees that are within a universe of general reasonableness, it's easier to defend those. If you have something that's outrageous, you're going to have to come up with some very compelling reason why the fiduciaries approve that characteristic. But in addition to that, you want, this process in and of itself doesn't mean much unless you can prove it. You want documentation that's clear, it's consistent, and it is documenting the most important decisions and the reasons for the most important decisions that were made about the plan. And what I mean by clear and consistent is, on this call, we're using terms that if I were to put my friends, 10 of my friends on, they would have no idea what we're talking about. All this would be over their heads because we're just using terms that most people don't understand. You have to think of your audience as the judge in these cases, and a judge who may have one or two horrific real fiduciary breach cases in his or her time on the bench. They get a ton of benefits cases, but I'm talking the real, what does it mean for a prudent process and a plan with hundreds of millions or billions of dollars in assets? And when they hear about revenue sharing, they have no idea what it means. Retail versus institutional shares start to make sense to them, but then they don't know the details of that. If you have the chance to prepare your own internal documentation, think about drafting it for a judge. Are there terms in there? Are you being consistent with your terms? I've seen documents in plans where they use record keeping fees. They refer to record keeping fees in different ways within their own documentation, even though in the communications they sort of knew what they were talking about. One was just the record keeping fee, one was a fee charged by the record keeper for a variety of services. Think about that. You want to avoid that, those conflicts, the lack of clarity, lack of consistency, because number one, the judge is going to be the ultimate audience for that. But those documents also are going to be presented to people in depositions who potentially haven't been involved in this stuff for years, some 6-7 years. Someone can be on a committee in the year 2020, plan could get sued in 2025, 2026, and a deposition a year and a half later. What do you think that person is going to remember? How helpful is it going to be to see 1 page of minutes and a report that uses terms that the person can't remember? Put some context to things. I'm a very, very, very big fan of explaining concepts, glossaries. I mean, things like that, where if somebody's reading it later, they know what you're talking about. And have people who understand what their job is within a committee. Not everybody needs to be a financial expert. Not everybody needs to be a people person with their finger on the pulse of the plan, the employees, and what the employees might want. But you want to put together that packet of information with the eye towards not just documenting that we did this, but documenting it in a way that if you have to present it to somebody, you can prove what you did and they're going to understand it.
To supplement what Rick is saying, what we found is most of these cases aren't going to a factual analysis on summary judgment or trial, but there are a few more going to summary judgment now. And what we're learning is it's really hard to prove that your process was good. Most of the employees have left the company by the time the litigation comes. And so you definitely want to try to keep your human resource people happy and staying at the company where they have knowledge. But these plaintiff firms, if they're good at anything, they're good at belittling the members of the committee that they maybe don't understand certain words, like what a target date fund is or to retirement, or they'll find something where they will belittle you in the deposition and make you look stupid. And they're just really good at it. And so we're finding it's harder to prove process. And the way we show that is some companies are winning on summary judgment. I've seen a lot written about the Home Depot case. Home Depot won after going all the way through summary judgment. They didn't win on a good process. They won on causation. And so what we're seeing is it's hard to prove that your process is good. And you're going to know that going in. And so we appreciate being on with a law firm that's realistic and credible here. We see too many law firms say, if you have a great process, everything's going to be fine. And what we're learning from these cases, you can have the best process with a great investment advisor, and you still can make judges don't understand whether you're they expect a lot. And the judges are unrealistic as to what you should be doing. And so to the extent most of the companies are winning, it's on causation. And that's a scary point. So it's just important to be sober and realize that even if you do everything right and document it right, that it's hard to prove fiduciary process in a court.
I'd be curious for the group's thoughts on this too. Does it also then, I think there was a trend some time ago to increase the size of these committees, right? Get more buy-in, more representation from within the organization. You know, if you ultimately end up in a position of litigation, it seems to me that the smaller the group, the better, right? The less people that could perhaps get overwhelmed with a question or forget the context of a meeting that took place 4.5 years ago. Any thoughts or perspective on that particular topic?
Well, we agree with that. I'm not a lawyer. I went to law school, but I don't pretend to be a lawyer. But I think you want a few really good people on your committee working with a great investment advisor. And I wouldn't do anything without at least a 321 advisor. And you want your advisor to help you and help you document it and get professionals. It's not what you do for a day job. So you get someone like Eric to help you through the process. That's the extent there's any kryptonite here. That's what you need to do.
And I think that's right. I mean, there's certainly no magic number of committee members, but the more committee members you get, I think the less kind of responsibility they feel, so the less involved they might be. If you get a smaller core group, they're going to be involved in absolutely using an investment advisor to help them, because odds are they're not investment experts, and so need that additional guidance to be helping them make their decisions.
Yeah, and the law exists for a reason, and I'm a fan of ERISA. I think it exists for very good reasons, especially if you know the history of some abuses early on. What it doesn't exist is to render people liable because they can't remember something during a deposition, and that is happening far too often. And I think there's a potential way to deal with that, and target date funds, that does come up. People will forget what that means. A document internally that just says, by the way, here's a target date fund. Then when they're asked in the deposition, what is a target date fund? It's right there in the document. It's so when we have been helping people, or I've been getting involved more recently in helping, some of the things I will try and do is to help draft that contextual information into charters, meeting materials, things like that, just to think down the road that if there's a deposition of somebody and they don't remember, it often, like Dan says, the process is fine. If you don't remember your process, then what help is it?
Fair. So I'll kind of close it out with kind of where we see the world going. I think, you've already talked, Dan, about more litigators means more litigation. And while I would always hope that, more dismissals means less litigation, I think you've made a pretty compelling argument that if you're yielding less, you just need to plant more crops. And as a result, maybe we'll have more litigation as a result of more of these cases being dismissed. I'm beginning to see more managed account litigation. And, Rick, you had mentioned kind of record keeping being just a component. I'm seeing increasingly cases where the revenue received off managed accounts may even exceed the revenue received for record keeping administration services, which seems to be it's something that certainly litigators have seemed to notice on the plaintiff side, and may cause some additional issues. And then I think we already talked about the target date, the BlackRock cases, and how that's pursued its way out. I think, Summer, how do you, since you sit in these committee meetings, right? You're typically part of the process from the, hopefully pre and never into litigation. But how do you help committees stay focused on participant outcomes when there are so many kind of potential issues that might ensnare them in litigation that they're obviously trying to avoid?
I mean, I think a lot of it is education and process. And, while Rick's absolutely right, process isn't going to save the day unless you can prove it. So I think that's another part of it, is making sure that they are understanding some of these cases and what's being raised and what they need to be thinking about, and making sure they're kind of using their advisor and having the regular meetings and going through the process of listening, understanding that information, discussing it, making decisions, and then documenting it so that they can, prove it if they have to.
A couple of questions have popped up. I know we've only got a minute left, so I'm going to try and get to a couple of them, then we'll respond to the others in writing. But I think there was the mention of kind of incorporating mandatory arbitration into retirement plans. With what frequency, or how common is that at this point, do you think, among retirement plans? And that may be an unfair question because you're looking at a limited sample size, but
I'm seeing more and more at it. It's at least something that plan sponsors or committees can do to try to, stave off something, even though, it's not perfect. There are issues with it, and, there are pluses and minuses with arbitration, but it's certainly something we're seeing more and more liking the thought of adding that if it, gives them a chance.
Yeah, and there are actually different types of arbitration clauses. there's just an arbitration clause that says all disputes have to be arbitrated, which is enforceable. That is enforceable, where I think that the courts are, that's enforceable assuming there's consent and things like that. But generally, there isn't really a substantive problem with that. Where the hangups have been on like the class waiver, individualized arbitration, there are different forms of arbitration provisions. We have been working on one with our clients where we will draft contingencies. So if a court decides that one aspect isn't great, there are other aspects that could kick in. So you can end up in arbitration. You can potentially deny the plaintiff's firm the third in fees that they're seeking. It could be a disincentive for them to pursue it. So we're trying to follow the cases and the reasoning of the cases, but Summer, I agree 100% that you can always waive them. You can, plan can put them in, and just if there's a lawsuit filed, just make the decision not to try and assert it and try to enforce it. But having it in there, especially if the law changes, I think is probably a good idea.
Well, I want to thank everyone for participating, both the audience for your participation and engagement. I got through as much as we could. There were a lot of questions on a lot of good content. We'll try and follow up on the last ones. And then also to the panelists, Summer, Dan, Rick, for your time and attention. I appreciate it. Again, the slides will go out. The question did come up, so we'll distribute those. You'll get them probably in the next day or two via email. So be on the lookout for those, as well as a copy of the recorded presentation. Thanks so much and have a wonderful end to your day.
Thank you.